Welcome back to the broadcast. Let's continue informing you. Now, can Kenyans finally hold their leaders accountable? Now, the IEBC announced a flurry of petitions to recall 4 members of parliament, with more expected against the ruling Kenya Kwanza administration. While optimism is high, this constitutional right to recall is anything but simple. It's a time-bound, arduous journey, challenging the very practicality of the constitutional provision. Jeff Kirui interrogates.
On Thursday last week, the new IEBC Commission revealed to receiving petitions seeking to recall 4 members of parliament. A culmination of widespread sense of betrayal from citizens, sparked by the passage of controversial Finance Bill 2024 that led to protest across the country. According to insiders within the IEBC Commission, the MPs facing recall include Tharaka Nithi Senator Mwenda Gataya Mofaya, Kikuyu MP Kimani Ichung'wah, Mathira MP Eric Wamumbi, Nairobi Woman Representative Esther Passaris, as well as North Imenti MP Rahim Daud. According to Article 104 of the Constitution, voters have a right to recall their legislators before the end of a term. To operationalize these, the Constitution directed Parliament to enact laws to provide for the grounds on which a member may be recalled and the procedures to be followed. In response, the National Assembly enacted the Elections Act that provided the grounds under which a member of Parliament may be recalled and the procedures to be followed. According to the Act, a member of Parliament may be recalled if found after due process of the law to have violated the provisions of Chapter 6 of the Constitution on Leadership and Integrity, if found to have mismanaged public resources, or if convicted of an offence under the Elections Act.
Order.
However, these provisions faced a significant legal challenge. In a 2017 case of Katiba Institute versus the Attorney General, the High Court declared Section 45(2) of the Elections Act, which provided the grounds for an MP's removal as discriminatory and therefore unconstitutional.
Where does that place us? And yet we know that Section 45(2) is one of the very salient provisions that provide for the grounds of removal of these particular parliamentarians. As we speak, once that particular finding, for instance in Section 45(2), has been made by the High Court, we do not have any specific grounds or template that will give us the grounds that we need to borrow from for us to recall the members.
In September last year, IEBC CEO Marjan Hussein Marjan, in a response to clarification sought by KMK Africa advocates on the process of recalling Tharaka Nithi's senator, highlighted that after the High Court declared unconstitutional Section 45(2) of the Elections Act that provides grounds for removal of an MP, the same cannot be applied for recall of an MP.
It is a bit difficult at the moment to recall or remove them from office as it is under Article 104, because if we try to do so, the members will move to court and it will be very easy for them to challenge that particular right, because there's a certain lacking 2 critical requirements under Article 104 of the Constitution. The other aspect is for the people of Kenya to wait for what we call the general election. Anything devoid of that will be anarchy.
Marjan further argued that the nullification of these vital sections poses a significant challenge to implementing any recall of a member of Parliament.
Once that particular determination has been made by the court, it was up to the House again to go back and see how are we going to fine-tune these particular aspects so that we realign with that particular constitutional finding.
In drafting the provisions to guide the process of recalling a member of Parliament, legislators put in place stringent measures that ultimately shielded them from the process leading to the nullification by the High Court. The requirements demanded that only a registered voter could initiate the process, supported by at least 30% of registered voters. The legislators also set strict timelines such that a recall cannot be initiated within the first 24 months or within the last 12 months of a term, giving disgruntled electorates a window period of just 2 years to exercise the right to recall.
It was by design by the parliamentarians to put in place such provisions or requirements, at least to safeguard themselves or protect themselves for the term they are in office, which leaves the people of Kenya the only opportunity of waiting the general election, unless these particular stringent measures are softened a bit to allow the common mwananchi to exercise this particular right.
Despite voters' anticipation for the reconstitution of the IEBC Commission with the hope of recalling certain legislators, it now appears the entire process is an exercise in futility due to these existing legal impediments. Jeff